All right, folks, let's talk about the substance and procedure of criminal law. Today, the law governs nearly every aspect of our lives. We are a litigious society. We see ourselves through the law, and we are structured in reference to the law. We have the substantive criminal law, or a body of specific rules that declare what conduct is criminal and prescribe the punishment to be imposed for such conduct. We have procedural law, or the laws that laws of rules of practice in the government, including the criminal justice system. Procedure covers everything from the investigation through sentencing. We have civil law, all law that is not criminal, including the law of torts and contract, property, maritime, and commercial law. We have a tort, or a personal injury, or wrong for which an action for damages may be brought. And then public or administrative law, which is the branch of law that deals with the state or government and its relationship with individuals or other governments. Historical roots: the Babylonian Code of Hammurabi. The earliest known criminal law existed in Babylonia. It was called the Code of Hammurabi, and it's based on the legal concept of proportionality. The legal perspective argues that the law should provide retaliation for harmed parties, but the retaliation should be fit to the seriousness of the crime, i.e., an eye for an eye. The Mosaic Code is another code practiced by the Israelites, i.e., the Ten Commandments, and it contains prohibitions against theft, violence, and perjury. These laws remain a part of the modern criminal code. And then the Wehrgild, or the monetary compensation system, which was developed for criminal violations after the Dark Ages. Guilt was determined by two methods: compurgation, which involved having the accused person swear an oath of innocence while being backed by 12 oath helpers, and ordeal-based, which was based on the assumption that a person who is innocent would survive an ordeal, like placing hands in boiling water or holding hot iron. I don't think I want that one, folks. We have to talk about common law and stare decisis. William the Conqueror sent royal administrators to travel throughout the land and hear cases of citizens to make decisions on stare decisis. Common law, of course, began during the reign of Henry II, when royal judges began to publish their decisions in local cases. These publishing decisions allowed for judicial precedents to be established, involved into a national code. Before the American Revolution, colonists were subject to the common law. After independence, state legislatures standardized common law crimes by codifying them. Some sources of criminal law: the contemporary American legal system is codified by state and federal legislatures. Criminal laws are not static. They evolve over time, especially when new behaviors arise that may need to be controlled. Criminal law is also changed by judicial rulings, which can rule laws no longer enforceable or expand the scope of an existing criminal law. There's some constitutional limits. All criminal laws must conform to the United States Constitution. The Constitution has been interpreted to forbid any criminal law that provides a person's right to be treated fair and equally. This is known as substantive due process. Laws are interpreted as violating constitutional principles if they are too vague, make a person's status a crime, they are bills of attainder, or acts that inflict punishment without judicial trial, or they are ex post facto laws. When a law is created, the legislator must demonstrate that there is a compelling state of interest in controlling behavior. Criminal laws that are too vague are often ruled unconstitutional. In reference to the bills of attainder, the Constitution prohibits bills of attainder, which are legislative acts that inflict punishment without a judicial trial. And the ex post facto laws make acts committed prior to the enactment of the law illegal. Crime classifications: we have felonies, misdemeanors, and violations. Felony, the most serious, punishable by long imprisonment. Misdemeanors, less serious, punishable by a sentence or a jail fine, a sentence to jail or a fine. And violations are just violations, like traffic violations and health code violations, where you pay a fine. The legal definition of a crime: all common law crimes contain both mental and physical elements. For example, a person who commits armed burglary, they willfully enter a dwelling, be armed or arm themselves after entering the house, or commit an actual assault on the person who is lawfully in the house, and knowingly and intentionally commit the crime. Both mental and physical elements. In reference to this crime, the prosecutor must prove actus reus, which refers to an illegal act. It can be an affirmative act, such as taking money or shooting someone, or a failure to act, such as failing to take proper precautions when driving a car. And then mens rea, which refers to a guilty mind, or the mental elements of a crime, or the intent to commit a criminal act. Actus reus is a voluntary and deliberate act. Failure to act can be considered a crime. Mens rea is acting with deliberate purpose or criminal intent. The relationship between mens rea and actus reus centers around whether a crime, the actus reus, and mens reus must be connected. The offender's conduct was the proximate cause of the criminal act, and the criminal harm, the actor's willingness to cause the harm, are established. For example, an intoxicated driver causes an accident that results in minor injury to another driver. The other driver heals from the injuries. However, 6 months later, the other driver dies of a heart attack. Because the actus reus, the criminal act of driving a car in the state of intoxication, and the mens reus, the guilty act, are not connected, then the formerly intoxicated driver would not be guilty of manslaughter. There you have it. Ignorance and mistake. As a general rule, ignorance of the law is no excuse. They might go easy on you, but they don't have to. Mistake of fact can be used in certain instances where it's an honest mistake, or the government failing to make the enactment of new law public, or an official statement of law that is incorrect. And then strict liability, where an offender can be held responsible for a violation independent of intent to commit the offense. In reference to strict liability of crime, the illegal act whose elements do not contain the need for intent or mens rea, usually an act that endangers the public welfare, such as dumping illegal toxic waste. Some other examples include narcotics control laws, traffic laws, health and safety regulations, sanitation laws, other regulatory standards as well. You also have to provide a criminal defense, which is based on a refutation of the elements of actus reus and mens res of the crime. Some defenses are based on excuses. These are situations where the defendants admit to performing the physical act of the crime but lack free will while committing it. And some are based on justification, where the defense claims the criminal act was reasonable or necessary under the circumstances. Some circumstances: duress, insanity, intoxication, age, entrapment. Duress is where the defendant must show they have been forced into committing a crime in order to prevent death or serious harm to self or others. Insanity, a legal defense that maintains the defendant was incapable of forming criminal intent because he or she suffers from a defect of reason or a mental illness. Intoxication refers to the involuntary intoxication wherein the defendant did not knowingly or intentionally consume an intoxicating substance. Age, or the law holds that a child is not criminal responsible for actions committed below the age when he or she cannot fully realize the gravity of their certain behaviors. And entrapment, where law enforcement used traps, decoys, and deception to induce criminal action from an innocent person. Something to think about: people who drink alcohol lose the ability to make rational decisions because their brain does not function correctly any longer. Should the loss of rational thinking be considered when prosecuting offenders who were under the influence of alcohol at the time of the crime? No. Unless you did not know that you were consuming the alcohol, that should not be an excuse. Just because you don't remember doesn't mean that you did not do it and should not be responsible. Some justifications for defenses: consent, or a person may not be convicted of a crime if the victim consented to the act in question. For an example is in sexual assault cases, where laws such as statutory rape, where the victim had given consent to engage in sexual intercourse, then the defendant would not be guilty. Self-defense, or to support a justification of self-defense, the defendant must have acted under a reasonable belief that he was in danger of death or bodily harm, and had no means of escaping from the assailant. Stand your ground laws is an example of this type of defense. Most self-defense statutes require a duty to retreat before reacting with physical force. An exception is one's home. Stand your ground statutes remove the requirement to retreat and allow individuals to use physical force without having to retreat or extricate themselves from a potentially harmful situation. Trayvon Martin was a good example of what happens when a state allows stand your ground. Necessity: sometimes criminal defendants argue that the crimes were committed out of necessity. They must show that, considering the circumstances and conditions, a reasonable person would not have behaved in any other way. And then, of course, law enforcement, police officers, firefighters, and the other first responders can use their occupation in defense of alleged law violation while in the line of duty. Sometimes this spills over to the private citizens, as in the case of the Good Samaritan laws.